Good afternoon, ladies and gentlemen. Welcome to season 3, episode 14 of the NBA-SBL Business Law series, being hosted by the Arbitration and ADR subcommittee of the NBA-SBL. May I use this medium to also welcome the chairman of the NBA-SBL, Mrs. Ozofo Ogemudia, and also council members here present, Ms. Fumi Osemebo, partner at ALN Nigeria, Aluko and Oyebode, as well as Ms. Sheyi Bella, partner at Banwo and Igodalu. At this point, permit me to yield to our host, the chairman of the NBA-SBL Arbitration and ADR Subcommittee, Mr. Ladipo Shoeton, for a formal welcome speech.
Yes, thank you. Thank you very much. The chairman, members and members of the SBL, esteemed speaker, the Netherlands Silk, distinguished guests, and fellow arbitration practitioners, ladies and gentlemen. Welcome to another fireside chat organized by the Arbitration and ADR Committee of the NBA-SBL. This is the second session organized by the committee this year, and our hope is that you will find this session even more useful than the previous one. Our topic today is strategic use of interim measures arbitration. Discussion on this topic has become necessary since the passing of the Arbitration and Mediation Act 2023. We gather here today acknowledging the complexities of modern arbitration. The stakes are often high, and timing is everything. Interim measures, also sometimes called provisional or conservatory measures, are temporary orders set by arbitral tribunal or even courts. They aim to maintain the status quo, prevent irreparable harm or the dissipation of funds, maintain business stability, protect intellectual property, or ensure the eventual enforceability of an award. We think that interim measures are likely to become an essential tool for parties seeking to protect their interests, preserve evidence, or prevent harm. However, seeking interim measures also carry risks and their considerations. Some of these are: one, the potential for conflicting court orders, increased costs and complexity, and the risk of the tribunal or court refusing the application. And of course, again, the impact on the arbitration timeline. Today, we'll delve into the nuances of interim measures, exploring types of interim measures, strategic considerations, for example, timing, jurisdiction, evidence preservation. Perhaps we'll have time to look at recent case law and trends, and also consider best practices for counsel and tribunals. Throughout this fireside chat, our special guest, the Silk, will share his experiences, insights, and expert perspectives. Our goal is to provide practical guidance on navigating the complex landscape of interim measures. I look forward to an engaging discussion exploring these strategic measures that have been newly introduced. And I wish us useful deliberations. Thank you very much.
Thank you very much, Honorable Chair. At this point, permit me to formally introduce the speaker for today's fireside chat. We will be delving in and breaking down to us the strategic use of interim measures in arbitration. He is no other person but the well-seasoned and well-known arbitrator, Mr. Lateef Omoyemi Kambi. Latif is a senior advocate of Nigeria and a member of the Body of Benchers, which is the highest body of distinction in the legal profession in Nigeria. He is a past chairman of the Lagos branch of the Nigerian Bar Association. He is the managing partner and the head of the dispute resolution group at the Sofunde, Osakwe, Ogundipe, and Belgorod law firm. And over the years, he has garnered valuable experience, particularly in the areas of commercial and tax litigation, as well as alternative dispute resolution. The Leonard Silk is a fellow of the Chartered Institute of Arbitrators UK, Nigerian branch, and has served in various capacities in the executive committee of the institute. You're very welcome, Leonard Silk.
Thank you. Good afternoon, Soebi. I must thank you for inviting me to share my thoughts and my insights with you. And also like to thank the leadership of the SBL, my good friend, Mrs. Ozofu, and the chairman of the arbitration committee as well. Thank you so much.
Thank you. I'm particularly very excited to delve into this chat, right? Basically because the area that we have decided to chat about is an area that poses a bit of problems or challenges for those of us who are in arbitration practice, even for those who are seasoned arbitrators. So let's start off by talking about the legal framework that governs the issuance of interim measures in Nigeria as well as internationally.
Yes, thank you, Soebi. You know, I'm as excited as you are talking about this area of arbitration practice, interim measures. Some people like to call it interim measures of protection. Some call it provisional measures, conservatory measures. It's known, by, different names. I personally like to call it preemptive remedies. I call it preemptive remedies because preemptive remedy is a generic word used for steps you take in dispute resolution before the actual fight. Pardon my word of the word fight, because arbitration, we don't fight in arbitration. But before the real battle starts, the steps parties take before that time, they're called preemptive remedies. And they include a host of measures. This includes anti-pillar orders, preservative orders, deposit for payment, and all sorts of things, including injunctions, which is what we're talking about, which we call freezing orders nowadays. So having said that, let me say that there's really no general or universal definition of what interim measures are, but it's best described by talking about its purpose. What is it? What does it seek out to do? The purpose of interim measures is really basically to safeguard the right of the parties in an arbitration. So it is an effective instrument or a very useful tool to safeguard the interests or the rights of parties. Why do I say so? Many times, just like the chairman of the arbitration committee said, Mr. Shueton, that in commercial disputes, time is really, really of the essence. So time is of the essence, and you find that in most situations, parties have decided to go into arbitration, and it takes a bit of time. But in interim, you need some time to safeguard your rights, so that at the end of the day, you don't find yourself in a situation where even when you get an award, the victory becomes Pyrrhic, or you get an award, you're able to enforce it. So that is a measure that allows you to ensure that at the end of the day, you're not left with empty victory. So certain steps have to be taken to ensure that things are kept in check, or status quo is preserved, is maintained. So to that end, you need to protect and preserve the rights in the temporary and interim measures. So that is, a bit of background about what interim measures are and the necessity for interim measures of protection. Talking about legal framework, they say that you really don't know where you are until you know where you're coming from. Where you're coming from tells you, allows you to assess where you are and give you an indication as to where you're going to. So talking about legal framework, I like to start from where we're coming from. Before 2023 or thereabout, when we had the old regime of the Arbitration and Conciliation Act, what party can do then, or what the law does for you then, or provides you with then, is that in an arbitration, parties can approach the arbitral panel for interim measures of protection. It doesn't really say that you can approach the court, but implicit in it is the fact that you can approach the court. Because if you recall, so that the schedule to the act talks about the fact that if a party approaches the court for interim measures, it shall not be taken as you having taken steps in arbitration. Because remember that the law on arbitration is that if a party seeks to go to arbitration, that party must not take steps in court. Because once you take steps in court, you're taken to have waived your right to go to arbitration. So what you had in that law was that in the procedure, the schedule to the act, it says that, oh, a party that goes to court to seek interim measures cannot be taken to have taken step in the proceedings. So it's implicit in it that you can approach the court. But the act itself does not say you can't go to court. All the act says is that, oh, you can go to the arbitral tribunal to get interim measures. That's where we're coming from. Now, where are we now? We're at a place where we have the Arbitration and Mediation Act that came into force in 2023 and gave a host of interim measures, in that law. Now, number one is that the law allows you now not only to approach the arbitral tribunal for interim measures of protection, also allows you to approach the court for interim measures of protection. So you can now approach the court for variety of interim measures of protection. One, either to preserve evidence, to get freezing orders, to maintain status quo, and a host of other things. Also to apply for preliminary orders, which I'm sure you're going to go to later. But to cut it short is the fact that the legal framework that we're dealing with now in Nigeria is that the law now allows you to go to arbitral tribunal for interim measures of protection when necessary and urgent, or you have the alternative of going to court either to seek for interim measures of protection or to seek for a preliminary order. So you have a regime now that allows you to do two. You can either go to tribunal or go to the court. Talking about, and also, I think it's important to also state that, there's this argument or this debate in Nigeria about whether arbitration is a matter in the exclusive list or is a residual matter, whether it's for the federal or for the state. Anyway, that argument continues to go on and on and on. But notwithstanding the fact that we have that argument, we have the federal arbitration law. We also have state law. Some states have adopted the federal law. A state like Lagos has actually did something a lot more different from what the federal had before the new law came into being. And under the arbitration law of Lagos State, you also can, since we're in Lagos, let's focus on Lagos. You also can approach the arbitral tribunal or approach the court for interim measures of protection, also under Lagos State law. So you have the legal framework talking about federal and Lagos, and we have adequate laws dealing with these measures. Now talking about international arbitration, depending on what institutional rules applies, what you find is that most arbitration institutions do not really set standards and principles for the grant of interim measures. The rules allows you to apply for them, but the standard and the principles are really not stated, leaving the arbitrator with wide discretion, wide powers to take cognizance of the national law, either the law of the seat of the arbitration or the law of the place of enforcement and recognition of the award, taking the laws into cognizance in determining the principles and the standards for the grant of interim measures. And also there are some case laws that I'm aware of the fact that the ICC redacted case law interim measures are available, so an arbitrator is left with these wide powers to grant interim measures in international arbitration. Thank you, Sadie. I hope this covers the framework.
Amazing, Leonard Silk. I think you've given us a lot to chew on there. Just a bit of housekeeping from my own end. We want this fireside chat to, in essence, be a chat. And so we need it to be as interactive as possible. So please, ladies and gentlemen, if you have questions for the very erudite Leonard Silk, you do well to pop your questions into the Q&A box at the lower corner of your screen. and I will be sure to take on your questions as we proceed. Leonard Silk, you spoke a lot about where we're coming from and where we are today. And you defined interim measures, you drew out the semantics and the different names, and what different people refer to interim measures of protection as. I'm quite particular about the innovations in the Arbitration and Mediation Act, particularly, and of specific reference here is the innovation of the emergency arbitrator. I want you to please shed more light on how this works right now in the arbitration scene in Nigeria. Do you think it is more strategic for a claimant in an arbitration process to go ahead to appoint an emergency arbitrator for the purpose of obtaining these interim measures? Or do you think that it may be more strategic to actually approach the local courts to obtain the interim measures of protection?
Well, quite frankly, CB, I think that a decision as to whether to approach an emergency arbitrator or approach the court, I think it's a matter of you taking maybe a commercial decision or a strategic decision, let me say. If I may explain what, or just shed some light on what emergency arbitrator is and, of what it is. You'd also recall that, like I said, in the old law, we never had the power to appoint an emergency arbitrator, even though, international arbitration, a lot of institutional arbitral rules, the LCIA rules, the ICC rules, they have, provisions for emergency arbitrator. Who is an emergency arbitrator and what is it required for? Now, what happens is that in a dispute, once there's a dispute, the party intends to take to arbitration. What the law says before now is that once you set up, once you set up the arbitral tribunal, arbitral panel is set up, and you know how it is normally, you send a request, you make your appointment. If it's a sole arbitrator, parties agree on the sole arbitrator. If it's joint, party A appoints one, party B appoints one, party A and B appointed arbitrators come together to appoint the third and the presiding arbitrator. All that process in practice could take you as many as a week, 2 weeks, 3 weeks, 4 weeks. In fact, in practice, it might take you, because most, laws on stuff will say 14 days after this, 10 days after that, 7 days after this, you can appoint this, appoint that. So when you do an aggregate of all the time frame for the appointment of the arbitral panel, you might have 28 days or 30 days or 6 weeks. A time which is enough for a party to do a lot of damage. A recalcitrant party or a party that intends to do damage can do damage in that time. Number one, in all that period, evidence can be damaged or destroyed in that time when you're doing your appointment. In that time, whilst you're doing your appointment, more funds can be moved around, to places where, you won't be able to reach them. A lot of damage can be done in that time. So what does it mean? So now, then experience dictates that, in that time, whilst you haven't, considered the arbitral tribunal, because the arbitral tribunal cannot make interim measures until and when they are appointed. So in the time whilst you're trying to appoint one, which may take you a long time, even you can have a situation where in the sole arbitrator, parties cannot even agree on the sole arbitrator. You have to go to court, you spend, time in court, all of this. Time, experience will show you that this can be really, really drawn out, especially when you have a recalcitrant party. So because of that, you can appoint an emergency arbitrator. An arbitrator, before the panel is constituted, an arbitrator can be appointed to deal with the matters of interim measures, so that before your appointment, you can go to court and you can go, between parties can agree to appoint one. The law allows that now. The Arbitration and Mediation Act, currently in force in Nigeria, now allows you, section 16 of that law now allows you to appoint an emergency arbitrator between the parties to deal with matters of interim measures before the panel is finally constituted. And when the panel is now finally constituted, the emergency arbitrator becomes functus officio or is no longer seized of the issues. So the tribunal can then take over from there, can decide to either modify, alter the interim measures that have been made by the arbitral tribunal. So it's really an emergency situation, and that is there. Then going to your direct question, should you one rather go to court instead of going to an emergency arbitrator? For me, the question will be it emergency arbitrator, be it a normal arbitral panel, which is more effective, either go to court directly or go to tribunal, be it emergency tribunal or the proper tribunal. Well, I would say depending on the parties you're dealing with, ordinarily, we know that in arbitration, arbitrators do not have coercive powers. They don't have the powers of coercion. So whatever award or interim measure you get from the tribunal, you still have to go to court for enforcement so that the court has the authority to enforce the award. So now the question is, should I first of all go to tribunal? If I know that the party I'm dealing with is responsible, honors agreement, I'll go to the arbitral tribunal and I know that I can get my award, and they would honor that interim measure without more. But sometimes the party you're dealing with, parties that person is irresponsible, is very recalcitrant, is very things are getting out of hand. This person I can't get this person to just honor this award without being coerced. In that situation, I think your best bet is to head to court, get your interim measure in court that has coercive powers. The court has, if a party refuses to honor the order of court, the court has powers of contempt, sequestration, and many other means of enforcing court orders, which an arbitral tribunal does not have. So you're placed in a situation where you have to decide as an arbitrator, or as a counsel or as a party in arbitration. Given the person I'm dealing with, what's my best bet? Should I go to tribunal, get my interim measure, will it be respected, or do I just go to court and get into court to make these orders? So that's what you're faced with. So it's really for one to decide, given the entire circumstances, before you, to determine whether you're better off going to the arbitral tribunal or going to court. I mean, not to say the court in our client does not have its own, its own quote unquote, I don't know what to call it, but what you face in Nigerian courts, the fact that things don't move fast enough, you're opening yourself up to different sorts of objections and all sorts of things that you would not get if you go to arbitration, because with the arbitral tribunal, they're time conscious, things that will move faster than they would move in court. So you've got to balance your situation. The arbitral tribunal, I get this faster there. Should I just go there? When I go there, then go for enforcement in court, or should I just go to court? I know that I'm going to get I'm going to enjoy the coercive powers of the court. So it's really for one to take a strategic decision as to what to do, given the party, given your opponent, and the situation you find yourself.
Thank you, Leonard Silk. So basically what you're saying is that it still is the obligation of the arbitration practitioner to determine in which direction to go. And one of the ways that the arbitration practitioner can do this is by assessing the party on the other side, whether that party is recalcitrant or whether that party is one that is likely to obey the interim orders as obtained. I mean, stemming from this, are there any strategies that you would advise arbitration practitioners to put in place just to ensure that their application is successful, whether that application is made before the emergency arbitrator or it is made before the court? Are there any strategic steps that you think that they should always have in mind, T's that they should cross, I's that they should dot, just to ensure that they always come out successful?
So I'd say that for me, the rule of thumb is that know your opponents. Once you know your opponents, try and second guess them, look at the attitude and all of that, and that will inform you into what to do. But in terms of strategies, I think talking as an arbitrator, I've been one, enough to be able to say that sometimes you also have to be, as an arbitrator, you have to be strategic in dealing with the counsel and the parties. So I'll give an example now. If you know that the interim measures you want to request from the arbitrator requires enforcement by third parties who are not parties to the arbitration agreement, then you have no business going to the arbitral tribunal for such. So you just go directly to the court, because you know that in arbitration, the agreement to arbitrate is based on agreement of parties. Two parties have come together to say, we want to resolve our dispute in arbitration, and we submit ourselves to the process, and we will be bound by that process, and we will honor the award. The third party is not part of that agreement with you. So you cannot serve, for instance, you want to get freezing orders, and you need banks or disclosure orders. You want disclosure orders from First Bank, for instance, or you want GT Bank to freeze an account in the interim. You have no business going to the arbitral tribunal, because GT Bank or First Bank are not going to be bound by that measure. It's only a court, the national court, that enjoy that kind of jurisdiction over persons that can make such orders. So it is strategic for you to know what is the essence of my interim measure. Is it directed at the party in arbitration, party in arbitration with me, that we have an agreement to arbitrate, or a third party? If it's a third party, you're better off going to court right away in order to get your order. Don't waste your time and go to arbitral tribunal. That's one thing to bear in mind. Then again, I've found myself in situations where I'm dealing with parties, and I know that these parties are recalcitrant, and I know that the moment I give my interim measure, what they want to do is head to court straight away and lock the arbitration and lock the process. Now, what I do strategically is that when I give my interim measures, I don't call it an award. It's never an award. It's an order. I do a procedural order, because I know that what you can challenge is an award, not an order. So your interim measure as well, you've got to know in what form is your interim measure. Is it in form of an award or in form of an order? Now, it's a double-edged sword. I've done it in form of an order before, and I just put it in a procedural order, so that the party that wants to challenge you would have that difficulty in court of challenging an order. What he challenges an award, not an order. Now, if it's an award, it's a lot easier for you to enforce it and to challenge it. Personally, and this is a personal opinion of mine, I like to make my interim measures in the form of an order, because I believe that an award must determine the right of parties, be it interim, provisional, or final. The essence of an award is a determination of the party's rights. Now, when you see interim measures, you are not doing that. You're not determining the rights of parties. You're only making a certain temporary orders that do not freeze this account until in a certain time, or make this disclosure until a certain time, without having recourse or regard to the rights of the parties. So for me, that is not the essence of an award. That's another reason why I would make in form of a procedural order. So if you do that as an arbitrator, you have to be mindful of the fact that if you make it an order, it might be difficult to enforce it. So perhaps you're better off making it an award, so it's easier for enforcement. So these are just practical things that you might encounter in dealing with this, or making the determination whether to go to court or to go to an emergency arbitrator.
Okay, thank you very much, Leonard Silk. I have quite a number of questions stemming from your most recent response to my question. But before I go to my further questions, I'd like to take a question from the Q&A box from Moses Omorikbe. He wants to know who will appoint the emergency arbitrator. We've been talking about the emergency arbitrator, but he wants to know whose responsibility it is to appoint an emergency arbitrator. Can you please respond to that?
Yeah, so if your arbitration is being conducted under an arbitral institution, that institution, you make the application to that institution to make an appointment for you. I think on that section, that's if it's institutional arbitration, that arbitration, the institute will make the appointment. But if it's under domestic, I think section 16 of the Arbitration and Mediation Act says that the court would make that appointment for you. in appointing an emergency arbitrator. I think you appealed the court. I believe so. I believe that's what 16 says.
Yes, the section 16 actually talks about the procedure for appointment of the emergency arbitrator, and it's quite specific on whether or not you need to approach the appointing authority or the court. So you
Yes, yes, the
Um,
appointing
but I'm
authority
gonna-
or the court, yes, thank
yes,
you.
or the
Yes.
court. I'm going to go back to all the dust that you raised, talking about where you have a third party involved and seeking to enforce against the third party. And then you also talked about issuing interim measures in the form, as an arbitrator, in the form of an order and not an award. But then the Arbitration and Mediation Act talks about the enforcement of interim measures and gives you the procedure for doing that, which is quite similar to the enforcement of an award. How do you reconcile that? How do you reconcile issuing an interim measure as an order that will now not be enforceable?
Yeah, so I mean, these are practical challenges. The section 58, I believe, that deals with enforcement of awards, talks about an award. It mentions an award, because if you look at the provisions of the law that deals with interim measures, it says that it can be enforced in the same manner as an award, meaning that it is what it's a provision that is contained in Section 58 that says that an award must be, in this form and all of that. Now, it is strict compliance. If it says an award and what you take to court is an order for directions or procedural order, that's not an award. I mean, that you might encounter difficulty there. And that is why I think one should bear in mind as an arbitrator or even as counsel when you are moving the tribunal to give interim measures to ensure that it's in a form that the law recognizes and the law would accept. Because the law, the provision of interim measures says that it shall be enforced as the same conditions as an award in Section 58 or something like that. So it's something to bear in mind in moving your tribunal to ensure that it is an award and not in form of a procedural order. I would do it in form of, if I know that it requires recognition, I'll do it in the form that the law says it should be in, and no other form. So it's just it's something to put at the back of one's mind that, okay, I'm going to enforce it. In what form does the law allow me to enforce it? In what form does the law, ask that it should be in? So I think I've thrown that up so that we can put at the back of our mind that, remember that when you're asking for these interim measures, you might need to enforce it. And in what form will the law allow me to enforce it? So, it's something that one should take cognizance of. It's worthy of bearing in mind so that you don't run to troubled waters at the end of the day.
Okay, and then still on your point of the recalcitrant party on the other side, do you think that this is where preliminary orders will come in arbitration? Do you think that preliminary orders can come in to prevent a recalcitrant order side from, frustrating the effect of an interim order issued by the arbitral tribunal?
Absolutely. Thank you, Sophie, for bringing that up. And preliminary orders, as you just mentioned, is one of the innovations in the new Arbitration and Mediation Act. In the law before this, we never used to have this. Although when the Lagos states, decided to be creative and forward-looking and promulgated or passed its own arbitration law, it made provisions for preliminary orders, which the old Arbitration and Conciliation Act that we had in Nigeria didn't have. But now, following the Lagos State example or Lagos State innovation, the AMA, currently enforced in Nigeria, the Arbitration and Mediation Act, now has provisions for preliminary orders. And just like you alluded to, preliminary orders are really there for you to ensure that a party does not frustrate the interim measures that you're going to ask for. So a party now, under the law, under both the the Lagos state law and the federal law on arbitration, can approach the court for preliminary order, a one-sided application. So just like people that go to court would agree with me, you know, in court, you have situations where parties file interim protection ex parte, where there's no time, there's necessity for you to move immediately, for you to act urgently. And because of that, by the time you begin to serve the other party and do all those exchanges, time might have gone, because time is of the essence in commercial disputes. So the party goes to court with a one-sided application, say, give me interim, you know, protection, give me injunction orders to last me 14 days, or pending when the parties are served and come back for the hearing of the motion and notice. Now we have a situation which is very similar to that in arbitration under our laws now, which is that a party can quickly, you know, go to the court, get preliminary orders, one-sided order, and you file that at the same time as you're filing your interim measures, and you say, I don't want this party to frustrate the interim measures. Interim measures will be heard, you know, later in the day, but in the meantime, hearing me alone, one-sided application, give me this order, and the court is empowered to give you that order to last for 20 days. So in that 20 days, you have that order, you can have things put in place. For instance, you have interim measures asking for deposit for payment, or asking for some money to be deposited somewhere, such that if at the end of the day, the tribunal makes an award, you have some funds to go after. You want such a funds to be kept somewhere. Now, or you want prison orders or disclosure orders to be made. And you know that before the interim measure is taken, the party can actually take steps. Once you serve them and you realize that this is what you want to do, you can take steps and hide the funds and destroy the evidence and other things. So you can go on a one-sided application, which I think is a fantastic thing. And it's one of the innovations in the law now, that you can go and seek preliminary orders, a one-sided application, so that things are kept in check pending when the interim measures is actually, application for interim measures is actually taken. So I think it's innovative, it's good, it gives efficacy to the arbitral process.
Yes, thank you very much, Leonard Silk, for that. You know, you had talked about the fact that the arbitration practitioner has the option to apply before an emergency arbitrator or the arbitral tribunal if set up, or to the courts for the interim measures of protection under the current Arbitration and Mediation Act. What will you say? Would you say it is efficacious, right, to, you know, go before the arbitral tribunal or the emergency arbitrator, because you have noted that the order or the award, that the interim award that is obtained, the interim relief that is obtained, still needs to be enforced by approaching the courts in the same manner like a final award? Wouldn't I be wasting my time, you know, going to apply for an interim relief from an emergency arbitrator or from the arbitral tribunal, when I know that I can still apply for the same relief directly from the court, noting fully well that I think section 16 sub 11 states that if I do apply from a competent court and I obtain that order, it does not invalidate or infringe or is a waiver to the arbitration agreement. Would you advise that I cut away the interim reliefs, obtaining that from the arbitral tribunal or the emergency arbitrator, and I go direct to the court? What would you say?
Well, yeah, thank you, Sebi. So for me, from experience, and the way I look at these things as a commercial dispute resolution person, is that I try to take a holistic view. So one is not better than the other in a way, and I'll tell you why. Both have their, you know, merits and demerits. Now, I have the option of going before an emergency arbitrator. And like I said, given my particular circumstance I'm facing, and the circumstance you find yourself in would say a lot as to what to do, what step to take. So I can paint you a scenario where I'm in a situation where, just like I said earlier on, I need freezing orders or disclosure orders from a third party who's not a part of the arbitration agreement. I have no business going to the emergency arbitrator or even the proper arbitral tribunal, because at the end of the day, they have no powers over third parties. So I'd rather go to court. Now, that's one. Two is that going to court as well has its own issues. Nigerian courts, we know the dockets are full. We know the process that we go through in court. You file your application, the court does not see it today, or it's adjourned for any reason. And you have to be mindful of not making that, not tying yourself down in court for a long time. Because you know that in arbitration, 9 out of 10 times, it will move faster than the court. So if the situation you find yourself in is that you know that this is not, my interim measure is not directed at the third party. It's directed at my opponent. My opponent, I know that, more often than not, it would obey or be bound by the orders of the tribunal. I get an emergency arbitrator or my proper consider panel if issues can wait, and appear before the tribunal and get my interim measure from the tribunal. Once I get my interim measure from the tribunal, if they don't obey it, I have to go to court. So time is a factor, apart from the fact that whether it's a third party or not. If it's a third party, like I said, third party interest is there. There's no point to go to tribunal, whether there's time or no time, just go to court, don't waste your time. But if I know that my opponent 7 out of 10 times or 70% chance of being bound by that award and deciding to honor the award, I'll go to tribunal because it saves me time. I know that in a very short space of time, we can get an award done, which we will not get in court because arbitral tribunal is faster than court. So I know I won't get that, timeliness in court. But if I know I'm dealing with a recalcitrant party, I'll just go to court straight away. But I know what, if I go to court, whatever award comes from the court, before the appeal is taken, you can be faced with all manners of, objections, all manner of, just waste time, which that the tribunal would deal with differently because they're more business-like than the courts are. So it really, you have to look at everything together at the time, the party you're dealing with, and all of that, and that would inform your decision whether to go to court or go to the tribunal first. But if you go to tribunal, you still need to go to court if the party does not, obey the award or respect the orders made. You have to go to court, which now looks like you're moving in, you're wasting time rather than go to court initially. You first of all go to tribunal, having gone to tribunal, now you're not going to court. It seems like that. But for me, sometimes it's a catch-22 situation. What do I do? If I do this, this can happen. If I do that, that can happen. So, but like I said, depending on your experience of arbitration and knowing the party you're dealing with and all other prevailing circumstances that you find yourself in, there is no right or wrong approach, whether to go to court or to go to the emergency tribunal. It's your decision to take, given the circumstances you're faced with, as which will be faster, more effective, and which would give you your result in a very short space of time. Remember, time is really of the essence in commercial disputes.
Thank you, Leonard Silk. I think my understanding of that is we deal with each case on a case-by-case basis, and we analyze each case depending on the surrounding circumstances, considering time, considering, the best cost-effective, strategy to adopt, and all of that. Yes, so that makes perfect sense. I have a question from Mr. Vincent Wasini. He says he's aware that parties are expected to bear cost of arbitration. He's asking, however, if this cost also applies to the expenses involved in obtaining interim orders in arbitration, including the appointment of the emergency arbitrator. He wants to know if both parties bear that cost or which party bears the cost. How is that treated in arbitration?
So thank you for that question. In arbitration, the golden rule in arbitration is that cost follow events. So at the end of the day, if you are the losing party, and the tribunal looks at your conduct and how you conducted the proceedings, whether through fault of yours, you dragged it and made it unnecessarily lengthy. All of that will take into consideration in awarding costs later. So at the end of the day, the cost will be awarded, depending on the successful party. The losing party will bear the cost of the successful party. So initially, yes, cost parties will bear, both bear the cost 50-50. But at the end of the day, the cost will then be allocated at the end of the day, and it will follow the event. So the tribunal will look at the events, how it has played out, and that event will determine which parties bear the entire costs in arbitration. So cost follow events, and that's the golden rule in arbitration.
Thank you for that, Leonard Silk. So Section 21 of the Arbitration and Mediation Act talks about the conditions for the grant of interim measures. So basically the conditions that the applicant has to satisfy to the emergency arbitrator or the arbitral tribunal in order to be awarded an interim, the grant of an interim measure. And one of those conditions is that the applicant must show that his claim is likely to succeed on the merits. Do you think that there is some sort of possibility of creating a bias in the mind of the arbitrator or the arbitral tribunal at the interim stage here? We all know in litigation how we always argue that the courts cannot delve into the substance of the matter at an interlocutory stage. If you apply that same principle here in arbitration, do you think that the arbitrator or the arbitral tribunal can validly satisfy or tick that the applicant has satisfied this particular condition without necessarily delving into the substance of the matter?
Yes, thank you. And I think, again, this is where experience in arbitration comes in. I see the point you're making, and I'm aware of the provision of not just our law, even other, even in international arbitration, the international rules all say that you must show, that your case is meritorious. You must show that I think the wording of our law is that there's a reasonable possibility of succeeding, in the claim. And the question now is this: how do you tell, a reasonable possibility of succeeding if you don't delve into the merit of the case? Now, you are not supposed to delve into the merit of the case at the stage in which you're considering an interim measure. Otherwise, you would have prejudged the case from the onset. That, of course, is a misconduct, and no arbitrator should misconduct itself, because at the end of the day, that will be a ground for challenge of your award. So again, this is where the quality of your appointment matters. You sink or swim in your choice of arbitrator in arbitration. If you get someone that is not seasoned or not experienced in arbitration as your arbitrator, and they fall for booby traps or make mistakes that amount to misconduct, what you will find is that you made the award very easy for the losing party to challenge it. Now, what does the law say? What the law requires at that stage where you're making a determination you're making an interim application is that the court looks at, so the tribunal looks at whether there's a prima facie case, whether on the face of it, it looks like you have a claim. There's some degree, not even some degree of success, but whether you have an arguable case. Now, I give an example. If my claim, for instance, is that I am entitled to Soyibi's shares, and the shares belonging to Soyibi were handed over to me. And at that point, I'm claiming ownership of the shares. And part of the document I'm using in making claim to those shares is a share certificate. Now, at that point, the tribunal looks at it that he's making a claim for shares. He has a certificate. It is not my duty at this point to determine whether or not the share certificates are genuine, whether they're not genuine, whether they're forged, whether they're not forged, or whether, there is been, how am I sure that, this claim is meritorious? No, without more, I've made a case that I'm entitled to a certain number of shares belonging to Soebi. They should be handed over to me, and this is the share certificate. That without more shows that I could succeed on the claim. Now, when you get to trial, at that stage, the tribunal can go delve into issues of, oh, okay, this certificate, how did it come about? Who has the custody of this certificate? Who has possession of the shares? Is there and the other party comes ahead and says, oh, actually, yeah, he has a certificate, he has a share certificate, but there's a share purchase agreement where I purchased this from him. These are matters that the tribunal will deal with when it gets to trial of the disputes. But at the point in which you're making interim measures, you don't delve into the substance of it to see whether, oh, what is the chances of success, or what is the merit of the claim. Just on the face of it, apparently on the face of it, does it appear that he has a claim? Prima facie means that without more, is there a case? So a tribunal should always be mindful of not delving into the substance of the tribunal and also of the disputes at that stage. Just like you rightly said, a court will not make substantive determination at the interlocutory stage. We do that, you could determine the matter before taking trial, before hearing evidence of parties. So tribunal also should be mindful of not doing that, because at that stage, you're not taking trial, you're not taking evidence. No evidence is required at that stage. All you're looking at is, based on the papers before me, without more, is a claim. So one has to be extremely cautious of not delving into the substance of it at that stage.
Thank you so much, Leonard Silk. I think we've talked a lot about the offensive, the claimant who is applying for the interim order. But what will you then advise a respondent who is on the receiving end of an interim order or interim measure of protection, who decides that it has not been properly issued or ordered, or decides that there are grounds to vacate same, or generally just wants to defend same? What will you advise an arbitration practitioner who is representing a respondent who is on the receiving end of an order that has been made?
Well, I think you have a variety of options. I mean, the one that comes to mind straight away is the fact that you can apply to have this, you can challenge it. You can challenge it that you want to vary, you have it modified, have it varied, or even have it challenged on the ground that there were misrepresentations made to the tribunal, and tribunal ought not to have made such orders, and all of that. So you're not without options to approach tribunal and say, oh, it ought not to have been made, or I want to challenge it on various grounds. You can't do that. Another vital tool for you as a respondent is the fact that you can also ask for security for cost. So you can say that, okay, fine, these orders of disclosure or these freezing orders that have been made against me, okay, if it turns out that it ought not to have been made in the first place, I want there to be security for cost to meet all my inconvenience and all the cost of the inconvenience I've gone through while this order subsists. So, for instance, a party wants a freezing order, say, for the sum of $2 million, and you can say, okay, you're going to freeze this. I can't, I'm not going to be able to operate, do business, and everything. What is my compensation at the end of the day if it turns out I ought not to have been made? Therefore, the tribunal can then make an order for security for cost of that inconvenience and all that you're going to go through. So, in addition to challenging it for purposes of modification, variation, or even having it discharged, you can also ask for security for cost to meet your financial cost of defending the application and also the inconvenience you're going to go through while that measure subsists.
Thank you very much, Leonard Silk. I think my final question, I don't know if the audience has any more questions for us on the topic, interim measures in arbitration, strategic use of interim measures in arbitration. But if not, my final question will be that we both agree that there's a lot of novelty around the use of interim measures in arbitration stemming from the Arbitration and Mediation Act, particularly the area of the preliminary orders, the area of the emergency arbitrator, even the fifth schedule, I think, that prescribes how you even approach the courts to apply for interim measures of protection. Do you see, or do you highlight, or can you pinpoint any areas of ambiguity that you would want to clarify for the audience today in conclusion?
Well, so as you very well know, so that most times the issues are not really for want of good laws, especially in our client. I always say that our laws are always adequate, for what we need them for. The issue most times is the operators of the law, the users of the law. Now, I think that people are still, it's a new law, came into force last year. People are still grappling with innovations in the law and all of that. And some of the procedures there are still going to be challenged and all of that. So for me, I think that it's for people to get acquainted with the provisions of the law and come to terms with it and know how to apply it. So how to apply the law is more important than the law in print. So the laws are there. Like you said, we have innovations, we have new laws to deal with situations. Now, how do we use those laws now? When do you apply for what? And in your application, what are the things you have to look out for? A party, for instance, that wants to preserve evidence must know what to do and how to go about it. The principles you have to, put before the court, the facts you have to put before the court to entitle you to those measures. You have to know, if you want freezing orders, you have to know what to show, irreparable harm, and harm that damages cannot, compensate for. And the law that really spelled out all the principles and the conditions you have to comply with in either asking for preliminary orders, asking for emergency arbitrators to be appointed, and different categories of interim measures. So it's for you to understand what fits your purpose and how to go about it. The law is what it says it is, but the operator of the law and the state of the law have to know how to use the law in such a way that it's to their advantage. They follow what the law says. And interim measures, they are really, really, really discretionary. And when we talk about discretion, we're talking about fact that, number one, no two circumstances are the same, no two cases are the same. So you have to know your circumstances, you have to know your particular circumstances, what you should ask for, what are the facts that you need to put forward to the tribunal or to the court in order to get what you want. One should bear in mind that interim measures are very effective instrument or very useful tool in resolving disputes, because they keep matters in check for you, so that at the end of the day, you don't have an empty victory. Once you realize that, then you have to know what to do to ensure that you keep matters in check, either to protect or preserve your rights, pending the final determination of the award. I give an example, and when I talk about it, still boils down to the users of arbitration. I give an example. Someone wants an interim measure of protection, and in your papers, it doesn't show that there's an existence of a dispute in arbitration. How do you want the tribunal to grant such, or the court to grant such interim measure for you? It is not clear that what you're asking for is temporary or provisional, yet you're asking for interim measure of protection. It's got to be clear from your papers, your affidavit, that there's an existence of dispute. What you're asking for is temporary. It is important that you have it. Damages cannot compensate for you at the end of the day. So these principles are in the law. You've got to be careful to follow them and make sure that you put yourself within the circumference of the law, what the law says.
Thank you very much, Leonard Silk. I think we are not doing too well with timing, but I have one question from the audience that I want to take, and I'm hoping that this will be the last question. It's from an anonymous attendee. The question is, and I read, if an interim measure is secured through an ex parte application, can the other party challenge the order in court? especially when the order has immediate impact on my business? Or am I expected to wait till the tribunal is appointed before challenging the interim measure?
No, certainly, if an interim order is made by the court, you can always apply to that court to have it challenged. Even in arbitration, if an emergency arbitrator makes an interim measure, the moment the proper tribunal is properly constituted and appointed, it can modify or you can challenge that measures made by the emergency arbitrator. If it's the arbitral tribunal itself, upon being constituted, that makes interim measures, you're not without an option of challenging it. No, you will always have your options. You're not without options of challenging it. So, regardless of who issues the interim measures, be it the emergency arbitrator, be it the arbitral tribunal itself or the court, you always have the right to challenge it and have it discharged or modified or varied.
Thank you very much, Leonard Silk. Thank you for such an insightful discourse. I think at this point, we have come to the end of the fireside chat. It has been very insightful. We've all learned a lot. I permit me to call on the chairman of the NBA-SBL, Mrs. Ozofu. I don't know if she's here at this time. She has a few words.
Yeah, yeah.
Thank you very much.
Thank you very much, Soibi. Good afternoon, our Leonard Silk and guest for today, Mr. Nkongbe. Thank you so much for
Good afternoon, Madam
taking
Chair.
time. I just wanted to say, I had to say hello because Mr. Nkongbe is my friend. We are neighbors. We work in the same building. So I thought it would be rude not to put on my camera and thank you. I know this is not your usual scene, but I was so pleased to see we dragged you out for the SBL and you delivered. I'll leave the rest of the thanks to my executive committee members, but I just wanted you to see my face and to know that we are all so grateful and excited that you could join us. So thanks so much.
Thank you very much, Madam Chair. Thank you.
Thank you so much, Madam Chair. I don't know if Miss Sheibella is here and has a few words to say, as well as Mrs. Osemebo. If not, may I yield to our host, the chair of the Arbitration and ADR Subcommittee of the NBA-SBL to close this session. Thank you very much.
Thank you very much, Soibi. I would like to start by thanking our most esteemed speaker, Mr. Kogbe SAN. I've thoroughly enjoyed the interplay between yourself and Soibi on this rather new but complicated matter. And from the discussions we had, you can see that a certain amount of experience is required in determining what approach to take when considering applying for interim measures. And I believe, at least I speak for myself, certain matters that I had concerns about have been made even more clear now. So thank you very much for making time out for this session. I'd like to, of course, thank our chairperson for taking time out to attend this. We were not expecting you. We were expecting a couple of other members of the council, but we're very happy to see you and to even have you say a few words. Thank you very much for joining us. I'd like to thank members of the committee, Mr. Onokoya and Amara Enogbenoeze, for all the work that has gone into this. I'd like to thank Rex and Endurance. They've been indefatigable as usual. A lot of work. They continually impress us by the standards to which they hold us. We had a practice session and we were all very, very pleased with the technical aspects of this presentation. I hope that everybody, over 100 people who have found time to attend this session, have found it useful. We are going to do more of this, particularly on the new innovations in the AMA. Soebi, our moderator, is in charge of our programs. So I know she's already dreading, but I'm coming back to you again. You know that we still have quite a few programs that we must present before our time is up. But thank you very much, everybody. I hope you all had a lovely time. And until we meet again, have a lovely day. Thank you.
Thank you very much, my Bon. Thank you.
Thank you, everyone. Thank you, Leonard Silk. Thank you so
All right,
much.
thank you, Soebi.
Thank you. Bye.
Bye.